Good afternoon, everybody. My name is Scott Schomer, and welcome to our seminar today. I'm very excited to see a full house, as we like to say. We have a lot of people here. So today we're going to be talking about wills and trust, and specifically the topic of the seminar is the 7 costly mistakes that families make with their estate plans and what you can do about it. So we're going to try to cover a lot of the topics that are concerns to a lot of people that are my clients, potential clients. And if we have some time left over, we'll spend some time with questions and answers. So welcome on this beautiful, beautiful sunny Thursday afternoon. It's good to see the sun back. So let's get into right to the heart of it, as I like to say. And that is, look at yourself in the mirror. My question to you is, do you have an estate plan? Well, if you don't, or if you don't know what your estate plan says, or you don't remember the name of your attorney that helped you, or you think it's buried in a closet or a safety deposit box, you should not feel bad. You are in good company. Unfortunately, just a few statistics here in the United States. If you look at the chart up on the upper right-hand side, what it says is that only 21% of us here in the US have a living trust, and about 35% of us have a will, which means almost half of us have done absolutely nothing at all. And as we're going to talk about more in more detail, if you have not planned, if you have failed to plan, or if you've done a poor job in planning, you're going to discover, or your heirs and loved ones are going to discover, that the government has a plan for you. Now, if you're like me, my guess is that you're not going to be real happy with what the government has in mind. And we're going to talk about that as we go through the seminar today. You know, the first thing you need to keep in mind and you need to feel good about is you're here today. So if you're in that category that does not have an estate plan or are concerned about it, at least you're thinking about it. You've taken the first step. A few more things that I call it on this chart. Of course, 95% of us want the chart in the middle on the top, want control over where our property goes. But again, if you've not thought about it or set it out, you don't really have a say. The government decides. And then the one that breaks my heart as a parent, the parent of 2 daughters, is the one in the middle, that only half of households with children have a will. And a will is the typical vehicle where you nominate guardians. And of course, the risk there is, you know, we make light of it, but it's the Lemony Snicket situation that a number of people can ride in and take charge and control of your children. Something to be concerned about if both of you are a parent or a grandparent. Do you have documents in place to make sure that your kids and your grandkids are raised by the right people? So these numbers, while not surprising, are particularly frightening in what I refer to as perilous times. So it's not just the fact that the government may make decisions for you, but also the fact that there's really a number of landmines that are out on the road laid in front of you. So what do I mean specifically by landmines? And typically what I'm talking about is are they landmines that risk and potentially destroy your wealth and intergenerational wealth? That's really something that we're worried about. So first up is that America has one of the highest divorce rates in the world. And if you've ever been in a divorce, you know how devastating that can be financially, and to watch your kids go through it can also just be a real exercise. And of course, divorces can have a very serious impact on estate planning. Next up are issues related to the end of life, and that is nursing home care. This country has really not figured out a good system to manage some of the end of life issues. And the average cost of a nursing home here in California is approaching $100,000 a year. And you thought college tuition was bad. And unlike college tuition, I don't hear any raging active debate for the president to give us some relief in this area. It is an ongoing problem. And as I'm going to get into and explain later, the average stay in nursing care and nursing facilities in this country is about 3 years. And so a really simple question is, do you have a spare $300,000 set aside in today's dollars to be able to deal with this contingency? After that is, since 2000, more than 5 million families have filed for bankruptcy. And an estimated 3 out of 5 of those bankruptcies relate directly and are due to overwhelming medical bills. That's really one of the leading causes, or the leading cause, of bankruptcy in our country. And that, of course, it's really not a surprise that one of the ways that we deal with it in this country is we do the intergenerational caregivers. It's estimated that more than 60 million Americans in the United States are providing full-time or part-time care for their family members, close friends, or loved ones. So this is sometimes referred to as the sandwich generation. You may have heard this term before. It refers to a child or an adult in their midlife that is both raising young children and also dealing and managing with the care of elderly parents. They're sandwiched between those two competing demands, and it can impact your financial well-being and your ability to save for retirement and all these things that are important. So those are some big landmines. And then, of course, the last and the biggest one that people don't really think about are lawsuits. Every year in the United States, more than 15 million lawsuits are filed. Now, anybody here today care to take a stab at how many of those lawsuits are filed right here in our dear own Los Angeles County on an annual basis? Well, before somebody says all of them, it's not quite that bad. However, one of the things that even surprised me as somebody that spends a decent amount of time in court, I was in court this morning talking to Judge Christian, Probate Department 44, is that the estimates are that there are 2.7 million lawsuits that are filed here in Los Angeles County. Our county only accounts for 3% of the population in the United States, but more than 16% of the lawsuits. It's rather remarkable. Los Angeles, in addition to being the home of the world champion Dodgers and hopefully the world champion Rams, is also the litigation capital of the world. Yay. Not sure that's something we ought to be proud of, but that's the reality. We have the single busiest civil court system in the world. Now, what does this have to do with estate planning? Well, it's really no surprise that as a result of lack of planning or poor planning, that a significant number of these lawsuits involve probate, wills and trusts, fights over poorly drafted plans, all of these types of things. And in fact, LA County is unique even among California counties in that it has 9 dedicated probate judges in downtown Los Angeles. I think the next closest county is Orange with maybe 2 or 3. We see a lot of this type of work. There's a lot of stuff going on. Now, how does this impact you directly? Well, it's difficult to sort of bring it down on a micro level, but just to give you a perspective, there was a report that was published a few years back in the Wall Street Journal, done by Accenture and the Williams Group, that estimated that 70%, 7 out of 10 of all families are going to be affected. They're going to lose inherited wealth, intergenerational wealth, mostly due to estate battles, fights, probates, all these types of things. And the estimated cost and loss to the estate, to these collective families, is estimated to be more than $30 trillion over 4 decades. That's just an astronomical, staggering sum. And it's a risk that 7 out of 10 of us are going to face. So have you thought about this? Have you thought about, how do I avoid this pitfall, this pothole ahead, this landmine in the road, all of these landmines that are in the road ahead of us? All right. So you may be saying to yourself at this point, well, gosh, what direction do I do? You raised some really good points here, Scott. Where do I go? What do I do? Well, let's start from the top with sort of a basic review of what your options are. What can you do to plan and protect for intergenerational wealth, especially the intergenerational wealth, if that's something that's important to you? Well, there are basically about 6 or 7 different options. The first option you've probably seen on a bumper sticker driving around town. I know that's a really weird thing to say, but the first option is basically spend every last dollar. We're spending our kids' inheritance. I know you've seen that bumper sticker before. It's a rather controversial one. It's also a pretty risky plan, because if you overspend and outlive your money, you're going to be destitute. And if you underspend, then you're going to find yourself in the same situation where you've got a pile of money left over and you've got to put yourself through the court system. So Not really what I would call really a great plan, but certainly, as you can see, with only about half of the people having made a plan, it's one that seems to be adopted by a lot of people. So realistically, what's the next one? Well, the next one is dying intestate. Now, I know that sounds like the latest form of Ebola or maybe the coronavirus. But what this basically means is this is the government's plan. Intestacy means you did nothing. You didn't plan at all for your demise. And as a result, the government has a set of rules and procedures and processes that it follows, most of which are boiled down to probate and probate court. And that is how your estate is going to be distributed. Just yesterday, I met with a lovely lady, and we went over things, and she was absolutely clear that her natural intestate heirs would be her two sisters. And she said, that's the last place I ever want my estate to go. I don't want it to go anywhere near it. Well, unless you sit down and you do something, the government has a plan for you. Option number three is to put everything into joint tenancy. Now, this is the most popular of what I refer to as the backyard estate planning techniques. This is where people sit down and they put other people on title to their accounts, or sometimes they put people on title to their real estate. So it doesn't work well with every asset type, number one. It also triggers and causes more lawsuits than I've ever seen from any other single technique out there. And I've been doing this for about 30 years. And I can't tell you how often people think, oh, I just put somebody on my account, it'll be fine. Their name will be on title, it'll be fine. And what it does is it results in a mess. It screws up tax benefits, including property tax rates and all kinds of things. So it's really one of your poorer options, especially since the passage of Proposition 19, if you've been paying attention to what was going on there. Next option, creating a simple will. So as I'll talk about later, more in this program, a will is a set of instructions to the probate court. You're writing a set of instructions to the probate judge. Hey, judge, here's what I want you to do with my assets. So they work, they're good for what they're good for, but what they impliedly mean in most cases is that you are dooming your heirs and loved ones to go to probate court. And is that really what you want to do? We'll talk about the downsides and the problems with having to go through probate court. Next option after that is to create what we call bare bones living trusts. Boy, I've seen some real doozies out there. There's all kinds of nutty stuff you can download on the internet, just like there are all kinds of crazy conspiracy theories. I've seen trusts. In fact, I had a trust that was actually prepared by somebody who called himself a lawyer. It was literally a page and a half. Boy, did we have to go into the court to get instructions to fill out all the missing pieces. So some people do this, and that's certainly an option that you have. Or the last, and I think the most superior option, is to prepare a complete family legacy wealth trust. And that's the type of work we do here at Schomer Law Group. And we'll talk a little bit more about that later if you have an interest in working with us. So as we go through your options, what is your plan? What have you done? Now that I've sort of laid out the world, where do you fit in the spectrum of these things? Have you done it yourself in the backyard? Have you been one of these do-it-yourself where you pull forms off the internet? Have you just done nothing? Maybe your plan looks like option number one or option number two, putting your head in the sand. So I hope not, but again, be optimistic because at least you're here today getting educated, so that's a positive thing. So is there a better solution than this? Is there a better solution than sticking your head in the sand? Absolutely, and I'm going to suggest to you, it's right in front of you. It's the Schomer Law Group. So before we get into the details more about what the problems are in the 7 causes, let me just spend a few minutes talking about who we are and how we can be of assistance. So I'm Scott Schomer. I'm the founder and the owner of the Schomer Law Group. I'm a graduate of Boston University. I've been practicing out here in California continually for more than 30 years. I am a certified specialist in the areas that we're going to be talking about today. I was certified by the California State Bar Board of Specialization in estate planning, trust, and probate law. I, of course, am the founder and the owner of the Schomer Law Group. I am also, and have developed through my practice, a financial planner, and I am an independent investment representative with Abundance Financial Coaching. So in addition to giving estate planning advice, I can also review portfolios and give you investment advice. I've received a number of awards and accolades over my 30 years of doing this type of work, including I've been recognized as a California super lawyer for I think a dozen years running. I've been nominated and designated as a 5-star wealth manager and a lifetime advocate member of the Multi-Million Dollars Advocate Forum, something that less than 1% of the attorneys in the country can speak to. All right. That's me, that's Scott Schomer, but that's not the Schomer Law Group. I am very, very blessed and lucky to have a number of terrific and qualified associates and team members around me. Just a quick review in addition to some, or introduction to some. First up is Melissa Padilla. She is our junior associate. She is a graduate of UCLA and Loyola Law School. She is very passionate about trust and probate litigation, has been doing a lot of the work and getting some terrific results for us on a number of cases. Now, missing from today is our senior associate, Nathan Coppernall. Nathan joined us about 4 months ago and is also very heavily focused in the probate trust and estate world. In addition to these two outstanding attorneys, we also have a team of paraprofessionals with decades of experience, including Caesar Gill, Nancy Berg, Daniela, Kara, Colleen, and Gina. We were very fortunate to have all of them on our team, and they're all here to help you and deal and plan with all of your estate. And because of the amazing team that we've assembled, in my experience, this is one of the reasons why about a decade ago we were invited to join the American Academy of Estate Planning Attorneys. The American Academy of Estate Planning Attorneys is a national organization. We are one of a few member firms, select member firms in the area that are members. We believe it is the premier organization in the country. We hold ourselves to a higher standard. I do triple the amount of continuing education than most of my colleagues do. I have a network of experienced attorneys, and we are here to help and solve almost any problem that you face in this area. So I think they're the best organization, but you don't have to take my word for it. If you're a reader of Money Magazine, as I am, Money Magazine recommended that if you're looking for an estate planning attorney, look for an Academy member, as did Susie Orman. I don't agree with everything she writes, but she also called us out and recommended that Academy members know what they're doing. So look for somebody like us. But you don't have to take the words of the experts either. We invite you in this day and age to do your own due diligence. We have a newsletter. We can send it to you. You can download it. We can email it to you. We also have a whole host of free reports and articles on our website, Top Estate Planning Techniques. If you provide us with your email address, we will update you on recent developments. In addition, we have a very active Facebook page, a Twitter account, a YouTube channel where I post a number of videos, and also a very, very robust blog. We have more than 1,000 blog posts talking about these topics. One of the things that I'm most proud about is I get calls on a regular basis from attorneys around the country who will go on and do their own research and write me and say, hey, Mr. Schomer, I've got this issue and I see that you've written on it. Seems like you know what you're doing. We could use your help. And I'm always happy to help out. So check us out, do your own due diligence. So that's what I bring. That's who I am. That's who we are. That's what we bring to the conversation today. So let's get in. Now that I've given you some background, let's get into our agenda, the mistakes. So first up, I'm going to talk about the probate mistake. After that, I'm going to talk about the long-term care mistake. Next, I'm going to talk about the creditor mistake. And of course, these are mistakes people make in either planning or failing to adequately plan, as I will illuminate more as we go through this material more. Next, I'll talk about the remarriage mistake. This almost sounds like a series of movies, doesn't it? It's kind of interesting. After that, the retirement planning mistake, the do-it-yourself mistake, the trust funding mistake, which is the most popular mistake. I will explain to you briefly a better solution, and then we'll spend some time with your questions and answers. All right, with all that being said, let's get into our first issue, the first mistake. First mistake we see people make more often than not is not making any plan to keep the government out of your business. In other words, people find themselves reliant on the government systems in order to transfer and manage their intergenerational wealth. What am I talking about more specifically? That dirty word, I'm talking about probate. What in the world is probate? I know you've heard about it. I know you have probably been told many times over the years that you should avoid it, you stay away from it at all costs. But what is it? What do I do? Well, probate is essentially falls into two categories: a living probate, something that you deal with while you're alive, and a death probate. That's the one that's more commonly known. The living probate is referred to as a conservatorship here in California. That word may be foreign to your ears, but you're probably used to the word guardianship. I think you get the concept of what a guardianship is. A conservatorship has probably been made most famous recently by the Britney Spears case. If you've been paying attention, we'll talk a little bit about those topics. But at its core, what is probate and why is it a problem? Well, for no other reason, probate is a lawsuit. Probate is a lawsuit, has been described as a lawsuit that you file against yourself for the benefit of your creditors. So the question I have for you is, do you want to sue yourself? Even the lawyers I know don't want to sue themselves, but that's essentially what you're doing when you're asking the court to take over and manage your estate after you're gone. You go through probate, it is a lawsuit to dispose of your assets. So why else do you want to avoid it? Well, obviously it is going to be expensive. There are court fees, there are publication and bond fees, there are executor and attorney's fees. The average minimum cost of probate in the state of California is 4 to 8% of the gross value of the estate. So you add up everything that's going through probate, and it's 4 to 8% of the gross value. So let me put this into real world numbers for you. Are you a homeowner? Look at the value of your house, not the equity you have in it, but look it up on Zillow. What is it worth? If you think your house is worth about $700,000, you're looking at minimum fees of about $34,000. If your home is closer to $1.5 million, you're looking at over $50,000 in fees. If your home and other assets are worth 2.5, you're looking at something close to $76,000 in minimum probate fees and costs. Ridiculously expensive. But the expense is not the only problem. There's also an issue of the timing that's involved. Probate is slow. I can't tell you how many times I have to tell clients that I'm helping on the probate side, you need to adjust your head to probate time. Probate time moves like molasses. The minimum amount of time you can handle a probate in California is 9 months. That's if you're just a rock star and you're hitting every single deadline and there are no problems. In LA County, because we are so backlogged, it's more typically 12 to 18 months. I've worked on probate cases that have been open decades, and it's not unusual for a probate to take several years. And by the way, while probate is open, in most cases, whoever the assets are designated for are denied access to them. So if your kids really need help and they really need the money, if they're not minors, they're not going to get that money until this whole probate period passes. And of course, it's open to the public. And if you have assets in other states, like in Oregon, maybe, you might find yourself with probate assets. But here's the thing that's probably most infuriating for me and most frustrating for a lot of my clients. And that is that because it's a government system, it's subject to all the same system failures and breakdowns that any other system can be dealt with. And so one of the really rude surprises we got in the COVID pandemic and the lockdown is that the probate court closed. It literally processed no business for about 4 months during the calendar year 2020. And why? Well, all you need to know is if you go down to the probate court, well, it's not like this now because so much of it's online. But if you went down to the probate court before the pandemic, you would see 20 to 50 people in every courtroom every morning. And it would be not unusual to have for a judge to have upwards of 50 matters on his or her calendar every morning. And it just didn't function during the pandemic. So we had matters that were scheduled to close like in early April, and boom, we just got notices from the court. Yeah, we'll see you in July. Nope, we'll see you in August. Nope, we'll see you in September. So you take that 12 to 18 months, and now you add another 6 months or a year on top of it. It's just absolutely frustrating. So that's your problem. It affects both probates. I've told you essentially what the problem with a death probate is, but the other problem is that a lot of people, even if they write a will, don't stop and think about the possibility that you may be in a living probate or a conservatorship. This is the court proceeding that's designed to protect you in the event that you become incapacitated. So again, it's made very popular by Britney Spears. This was the most popular one. But if you have a stroke or you develop Alzheimer's and you can't care for yourself and you've not planned, what happens is the court takes control and jurisdiction. They appoint somebody to be in charge of your affairs and they run your business, and then you have much less say. So it's not completely self-evident already. Why in the world do you want to avoid one of these? They're humiliating. The court is in control. It's time consuming. By the way, the court in control, I've had a number of cases where, especially when you have blended families, like there's been a second or a third marriage, where perhaps the husband becomes incapacitated, the new wife goes to apply to put him under a conservatorship, and lo and behold, the kids from the first marriage write in and say, no, 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 no. No way do I want my stepmother to be the conservator. I'm fighting this. I'm putting up a battle. And boom, suddenly you're having a trial over who gets to be in charge of your person who's incompetent. So you saw a flavor of this in the Britney Spears case when various people were fighting to be in charge, to be the conservator, to be the lawyer. These things are ridiculously expensive. And you don't have to be Britney Spears to have them be expensive. Just showing up in court, hiring a lawyer is very expensive. So there's court fees, attorney's fees, accounting fees, the whole idea. Uncontested ones, we usually budget about $10,000 a year just to get one established. If you're fighting, you can multiply that $10,000 a year by 2, by 5, by 10. Yes, I have seen a number of conservatorships where the parties are spending more than $100,000 a year in legal fees. All of this can be very simply fixed and remedied by planning ahead of time and not leaving your care for your incapacity up to the government. This is the government system if you become incapacitated. All right? So that's mistake number one. Don't make mistake number one. Don't go to probate court. What's mistake number two? Let's get to it. Mistake number two is not planning for nursing home care. Most plans or forms off the internet or homemade stuff don't give any thought as to how you're going to pay for these costs, especially if you don't have adequate resources. With the average cost of nursing home care approaching $100,000 a year, this is a pretty serious mistake. So how do you pay for long-term care? How do you pay for nursing home expenses? A lot of people just assume that these expenses are covered by their health insurance. Well, I've got some bad news. There's very limited coverage, especially for long-term care issues, such as Parkinson's disease, such as Alzheimer's disease, such as dementia, things that require regular long-term care. So the 5 ways that you do it are: number one, you pay for it out of your own pocket. That's obvious. Number 2 is you buy long-term care insurance. Long-term care insurance can be a great product, but you can't buy it when you're incapacitated. You have to buy it in advance. And the reality is that most people have not made the effort or not purchased it. The 3rd way is you could apply for limited Medicare benefits. So if you're over 65, Medicare is your health insurance. The Medicare benefits will last about 100 days. That's about as much as you get. And if you've not rehabbed yourself enough to survive on your own, then those benefits come to an end and now you're back to either paying for yourself or using one of the other programs. Number 4 is if you're a vet. In some instances, there are limited aid and attendance benefits. The program of last resort is called Medi-Cal here in California, called Medicaid in the rest of the country. Medicaid is a joint state and federal program that's designed to keep our seniors from sleeping on the street. But the critical thing is essentially in California, although the law is changing, essentially it has an asset test, asset and an income test. And what they want you to be is destitute. So if you're prepared to spend yourself into poverty, there is a plan to care for you. But there are better ways to do this, but it requires that you plan and you think ahead a little bit. All right, that's mistake number 2, not thinking about long-term care expenses. How about mistake number 3? Mistake number 3 is no divorce, creditor, or lawsuit protection for the beneficiaries or heirs. What's going to happen when you leave money to your loved ones, your friends, to the next generation? Are they prepared to handle and manage sudden wealth? Do they know how to do it? Do they know how to invest? Do they know how to not make stupid spending decisions? Do they know the basics, even like insurance, right? Have they adequately insured themselves from potential loss? Now, you may laugh at this one. I've had numerous versions of this case. I had one that comes to mind is I had a gentleman, we'll call him John, who had never received a dime in his life, never owned a car. He got a bunch of money, and the first thing he did is went out and bought a brand new red Corvette. And it didn't dawn on him that he needed to have the Corvette insured. And because he didn't have a lot of experience driving, he didn't know how to drive a Corvette. And within about 3 months, he had wrecked the thing and gotten himself in a lawsuit because he had injured somebody. And lo and behold, within about 6 months to a year, he had wiped out his entire bequest. Is this really a good use of money? Is this really a good use of your money? Is this how you want your kids to handle it? What about marriage and divorce? You may love your children, but have they picked good life partners? Even if you think they've picked good life partners, is there a risk here? Can you protect the inheritance from going to the ex-spouse, especially if the ex-spouse isn't going to pay child support or isn't going to support your grandchildren or the next generation? This is a very easy situation for people that don't think about this, to watch half of an inheritance walk out the door in an instance. Finally, the next thing in this category is what we like to refer to as the Nordstrom's problem, and that is, are your kids prepared to manage the money? Are they financially mature enough? Right? Are they going to do stupid things with it? Are they going to blow it? Are they going to spend it? Are they going to feel like it's a party like it's 1999 and they're going to watch all the money go? So this is one of the things that keeps a lot of our clients up at night. There are ways to manage and deal with this, but you've got to put some time and effort into thinking about if it's important to you. And this is something we help with families with all the time. Okay, that's 3 mistakes so far. Let's go on to number 4. What about remarriage? Remarriage. So where we typically see this is where we have a long-term couple married together. The first spouse dies, leaves everything to the surviving spouse, and the surviving spouse might go out and remarry. The surviving spouse often remarries somebody that is significantly younger than him or her, or even a little younger than him or her. And it's not unusual that it's a blended family. And so the question becomes, are your assets, if your desire is to have your assets go to your kids, are they actually going to go to the kids? Or are they going to go to the spouse of the new, the kids of the new spouse, somebody that you don't know, that you've never met, and you're going to find your, having died, having left your kids with no inheritance at all. So this is particularly important, this consideration, in blended families. If you were on a second marriage or a third marriage, if you got yours and she's got hers and you got separate piles, have you thought about how to manage and keep everything fair when you're gone? So that's mistake number 4. We can plan, anticipate it, but the reality is that most people don't think hard about it. All right, mistake number 5, no retirement protection. So I'm dealing with a probate estate right now where a decedent didn't name a beneficiary on a 401k. Most likely the result is going to be that the entire 401k is going to have to come out, going to have to be distributed to the probate estate. The tax is going to be owed on the probate estate. Trusts and estates, by the way, if you can't pass the income through, pay the highest tax rates of any of us. And it's going to be catastrophic for most people involved. But the other thing is that under the Secure Act, beneficiaries are allowed to stretch IRAs and stretch the tax liability over a decade. But have you set your plan up to adjust and deal with this? Do you have somebody that you want to take care of that has poor impulse control, or doesn't understand taxes, or doesn't understand finances? Will they make a stupid mistake that will penalize them for the rest of their life? That's planning mistake number 5. Think through these things and we can guide and adjust you, but you need to spend some time doing it. Mistake number 6. This is the bare bones trust, or the do it yourself. So I try not to laugh, but I see this mistake on a regular basis. I've had people come into my office and say to me, well, I'm here, I don't really need your services, Scott, because I already did a trust. But I just want to make sure everything's fine. And they'll hand a document to me and I'll look at it and I'll say, that's not a trust. What you filled out there is a power of attorney or an assignment document, or that's a summary. You signed the wrong document or the wrong form. And I'm going to give you an example of this in a few minutes, a really interesting example that came from my practice, to show you even lawyers make mistakes in this area. But do you really know what you're doing? Right? I don't perform brain surgery. I also don't hardwire my own computers, because even though I know how my brain works and I know how computers work, I'm not trained and I don't have the knowledge to be able to do this. So do you really understand all the technical reasons why you do a trust, why you set up an estate plan, how you maneuver through probate court? Are you really confident that you can do this yourself? This is probably one of the biggest sources of our non-planning side of the business, is people who thought they knew how to do it and just screwed it up. So don't be one of those clients if you can help yourself. All right. 7th mistake, and the most popular one, not by choice, is what I call the funding mistake. So a lot of people say funding. What does that mean? What do you mean funding? So funding refers to a trust. And I'm going to explain to you a little bit later what a trust is. But for the purposes of today's seminar, at this point, think of it as a treasure chest. It's a private treasure chest you create. And the purpose of creating a trust is that you want to fund your assets into the trust. Once they're inside of your treasure chest, they're protected and they're safe, and the people that you want to get them should be able to get them. So the mistake we see, and even with people that go to lawyers, is that the vast majority of trusts are not properly funded. Nobody takes the time and effort to do the funding. We see this on a regular basis. And if the asset is not funded in the trust, it is more often than not a one-way ticket back to the probate court. You've got to get the probate court involved, even if you have a pour-over will. Because remember, the last term in the phrase pour-over will is will. And like I said earlier, a will is a set of instructions to the probate court. So what do I mean? So let me give you this marvelous, horrifying example that we experience here in our firm. It ties together a number of these things: the do-it-yourself, the lack of funding, and it's kind of a funny humorous story. I've changed a few names to protect the innocent, but you get the basic idea. All right, so let's meet Howard and Claudia. You've probably seen their faces before from some other famous movie. So in 1994, Howard, who is an attorney, sits down and he writes a trust and a pour over will, does it himself, thinks he knows what he's doing. So he owns a house and other assets, but he never funds the trust. So he writes the trust, but he never does anything to put his assets into the trust. And there the trust sits, okay? So in theory, he has an estate plan, but it's not set up for success. That's 1994. Now let's flash forward 4 years later. Howard gets lucky. Howard receives an inheritance from his parents, $3 million. That's terrific. But what does Howard do? Howard goes down to his local investment advisor and he opens up a financial account, and he doesn't put it in the name of the trust, and he doesn't designate a beneficiary on the account. It's just in his individual name. Now, the educated and the clever among you might say, well, wait a minute. There's a pour over will, maybe, and maybe there's a schedule of assets. Is there some other way we could get that account into the name of the trust? All right. Well, this is Howard's schedule. Howard listed his house. He said a house ad, and he took the address off. Then he says personal property, and then category number 3, money market funds, bank accounts, and investments. So does that mean it's in the trust? Well, it's not. It's not enough. Now, if this wasn't bad enough, if Howard hadn't already screwed this up enough, Howard took it one step further. Howard went back on the internet about 10 years later, about 2009. Howard sits down and he pulls off and prepares. Remember, Howard's a lawyer. Howard prepares something called a California statutory will. Here's the actual form. We've not reviewed all the things, but you can see Howard's name. And so he pulled this form off, and Howard's desire and intent is that he wanted to leave everything to his girlfriend, Claudia. You met Claudia earlier in the seminar. So you can see Claudia's name there, and he decided that she was going to get the residence, and she was going to be the executor of his estate. Okay. Well, problem number 1 is we now have 2 conflicting sets of documents. We have the estate plan that he did in 1994, the will and the trust, and now we have this new will that doesn't talk at all about his trust and doesn't reference his trust. Okay. But shouldn't it be enough to transfer his investment account to his girlfriend, Claudia? Well, here's where it got really entertaining. Poor little Howard left blank the part that dealt with his other assets, the balance of his assets. Most likely he made a mistake. He just forgot to fill that part of the form out. But you can't use most likely in probate court. That's not a legitimate reason. He either filled it out or he didn't fill it out. And if he didn't fill it out, then the court is required under the law to follow the laws of intestacy. Remember what I talked about, the government's plan? If you don't have a viable plan, the government gives you their plan. Well, under the government's plan, his assets went not to his girlfriend. She's not related to him. His assets went to his siblings, to his family members. So that $3 million investment account, off it goes to the siblings. But in reality, that's not exactly what happened. Because, as you can imagine, poor little Claudia was a little upset with what happened here, as were the siblings. And lo and behold, along came the lawsuits. She sued, he sued, probate opened, back and forth, 6 figures in attorney's fees, easily $100,000 attorney's fees on each side, fighting over who gets this investment account. All because Howard forgot to fill in the one blank about his girlfriend getting the bank account. That's it. Disastrous. Ladies and gentlemen, we see this stuff all the time. This is not a total unique case. We see variations on mistakes like this on a regular basis. Do you really want to wade through this and trust this to somebody that doesn't know what they're doing, or take the risk that you did it correctly when you're not going to know until it's too late. So in summary, what we've been talking about is ineffective planning. There's been no protection from probate court. There's been no protection from nursing home costs, no protection from lawsuits, creditors, remarriages, all the things we've been talking about for the part of the seminar. So at this point, I would hope a thought like this comes to your mind. Yes, please, Scott, is there a better way to do this? And oh my gosh, yes, there is. And it is so much easier than you can imagine. It just takes a little bit of time, patience, and money. So the point that I want to do, the cleaving that I want to do right here at this point in the seminar is I want to talk about the distinction between public versus private. So the government plan is the public plan. What I've been showing you all along is the public plan. That's the plan of last resort. Rather than getting on the airline, that's you taking the bus from here to New York, right? Would you rather take the bus or would you rather take the airplane? In the end of the day, if you have to be out of work for 5 days that it takes to get from here to New York on a bus, while you may save a few pennies, you're going to spend a lot more of your time and productivity that could be better spent. So what's the private method? The private alternative, there's no special club or handshake. All it requires is that you do a little planning, and it mostly relies on you signing a series of contracts. Contracts, that's it. We've all signed contracts in our lives. Every time you open software, you agree to a contract. That's all you have to do is you have to sit down and do some contracts, and you can get on the private system and do this so much more easily, so much more efficiently. So let me be a little more specific about how this works and illustrate it for you. So not for everybody, but for the majority of us, the key contract in a good estate plan is something called a living trust. I'm sure you've heard the term before. So what is a living trust and how does it work? For your purposes, a living trust is nothing other than a three-party contract. So who are the three parties? The first party or parties are the trustors. Those are the parties that set up the trust. So if we have Bill and Mary Jones, a husband and wife, and they create the Jones Family Trust, they are the trustors. They set it up. This position is sometimes called the settlors. They settle the trust. That's the first position. The second party or parties are the trustees. They are the people that run or manage the trust. And I'll get to that in a minute. The third party or parties are the beneficiaries. Now that's a big fancy legal word, but look at the root of it. Benefit. Who is going to get the benefit of the trust? Who's going to get the treasure inside of the treasure chest? Those are the beneficiaries. And so who are these abstract people? Who are we specifically talking about? Well, again, if we're talking about a married couple, we're talking about Bill and Mary, guess what? They serve in all three positions. They set the trust up. They're the trustors. They are the initial trustees. They run the trust. They make all the decisions. And they are the beneficiaries. They get the benefit of the trust and all the treasure inside of the treasure chest. It is, in fact, for Bill and Mary Jones, business as usual. They remain in control. They can amend or revoke the trust. They can update it. They can leave more money to somebody else. They can appoint a new trustee as a successor. They can do whatever they want. They can buy and sell assets, and there's no new property, no new income tax forms, and there's no change in your property tax rates. It is business as usual. So stop and think about it for a second. You are signing a contract with yourself or yourselves. And you might say to yourself, well, that seems kind of crazy. Why am I signing a contract with myself? Well, the way that I like to think about it is this is the best contract you'll ever sign. And why? Because it's a contract and a standby device. It's a contract that creates a standby device to protect you, to protect your loved ones in the event that you get disabled or when you eventually pass away, which is going to happen to the best of us. I haven't met a vampire who lives forever. So this contract is a set of instructions to those people who are in charge and allows them to work outside of the probate court without judicial involvement, without all those fees and costs and delays. And it can be set up to do some miraculous things to protect you, to protect your spouses, to protect your loved ones, your children, your grandchildren, and the whole shebang. So, covered a lot of information today. I've given you the core of what the important thing is. I've talked to you about the 7 big deadly mistakes. And at this point, we're sort of at a defining moment. I've given you the knowledge and the information. The question is, how are you going to be remembered? If you do nothing, you are going to be remembered as the person that left a whole series of lawsuits behind for your loved ones. A plan that was a mess. People had to go running around, court battles. And if you thought the kids were good at fighting in the living room, you haven't seen anything until they start fighting in the courtroom. I was at a court hearing about 2 years ago where there were 7 family members standing in front of the judge. And the judge looks over and says, okay, we're going to try to get this resolved. I'm sure you guys all want to get along. And I literally saw one of the kids at the end. It looked like he was the oldest. He stuck his hand up and said, Your Honor, we actually don't want to get along. We don't like each other. We want nothing to do with each other. Wow, you do that in a court of law and you better get the checkbook out because you're going to spend a whole bunch of money doing that. So is that what you want to do, or do you want to leave behind a plan that works and leave your memory as good a steward as you were during your lifetime? There's nothing that makes me happier. There's nothing that brings me more satisfaction than knowing that I've helped clients button these issues up, make it clear, make it understandable, and make the transition easy and simple for my clients and their loved ones. It's an absolutely fabulous thing. And I hope we can deliver that for you. So we've given you the knowledge, but knowledge is not enough. You actually need to do something. So what does it take and how do you get involved? And how, now that I've hopefully opened your eyes, what's involved? Well, what's the cost of failing to plan? It's really a function of what your asset base is, but there's some pretty basic assurances. Like if you're going to do a conservatorship, you're probably looking at about 10 grand a year. If you haven't thought about nursing home costs, hundreds of thousands a year. If you're talking about probate, it can be tens of thousands. So what are your options? Well, I'm going to quote a fee for you in a minute, but as I like to say, you get what you pay for. There's a few places in life where you don't want to skimp. I've talked about brain surgery and parachutes, fire extinguishers. I came across this book in Barnes and Noble. Yes, there's still one open a few months ago. And so this is something that I don't want to do. I don't want to do it myself. And why do you want to not do these types of things yourself? Because you're never going to know you made a mistake until it's too late. And when you've got to fix mistakes like Howard in our earlier example, you're going to have to write really big checks and your heirs are going to suffer. So let's do it once. Let's do it right. Let's do it in a way that preserves and hopefully grows your intergenerational wealth that isn't a drag on it. So for the estate planning side, we do a complete package. It's the only way. We're not gonna do one little thing or another. We just don't tune, but we do a complete package. And for that, we charge the total fee of $5,495. That includes protection from all the things I've been talking about in this seminar. Keeps you out of conservatorship court, keeps you out of probate court, it figures out ways to protect and divide your assets fairly and equitably according to your directions, lets you be in charge and the people that you love and trust in charge, and not the government's system. So let us help you do it right. We've helped hundreds of families. We know what we're doing. We know how to do it, and we can get it done for you efficiently and plainly. So for joining us today, we are offering you a little thanks and a little gift, because if I have to educate people of this one at a time in a meeting, it takes a long time. So we're giving you a $700 credit. So we are offering you an opportunity to come in and sit down, most likely with me, on a one-on-one or two-on-one consultation, a private attorney-client consultation. If you've done a prior plan or a prior will or trust and you're not sure if it's any good, you can bring that in and we will look at it. We will give you our 2 cents, provided you just didn't get it done last week. But bring it in, we will give you our 2 cents on what to do and how to do it. Here are the only requirements. that we have in order to take advantage of this opportunity is we ask that you schedule this appointment in the next 2 weeks so that this information is fresh. The second thing is that if you're a married couple, I really need both of you there. I can't do this twice. That's one of our requirements. And the third thing is, while there's no obligation and no fee for our initial consultation, we do ask that you be prepared to make a decision. Now, if you're the type that's going to be shopping or doing something else like that, or you'll make a decision in 5 years, then call me in 5 years. This is there's such a demand and there's such a need out there. I want to help people that are ready to get something done, and we're willing and able to help. So our consultations can be done in person. We are fully vaccinated and we wear masks depending on the client's preference, but we also love them by Zoom. We can even do them by telephone conference. So that's easier for you. We'll do just like this webinar is over Zoom. We can set it up and we have lovely consultations. I would love to see you. So if you take advantage of this, what can you expect? What will this conference be like? Well, the first thing again is you're going to be meeting with me. You're going to be meeting with an attorney you're going to get right from the horse's mouth. So the first thing is we ask that when you come in, that you let me get to know you a little bit. Because it's an attorney-client consultation, the information that you share with me, which might be more than you share with your priest, is confidential. I have to keep it, preserve it to my grave. So let me get to know you a little bit. Once I get to know you and your situation, I will turn the platform over to you and let you ask any questions you have related to these areas that we've talked about planning, about long-term care, about all this type of stuff. So we'll go over all of those types of things. Third is we'll sum up and I'll make a recommendation. My recommendation could be, you're fine, you don't need to do anything, or my recommendation may be, we have a 3-alarm fire here and you need to get a plan in place right away. Finally, when we get through with that, I'll ask you to make a decision. Yes or no. You can tell us no, we're big people, but we need to know, is this going to be our responsibility or is it going to be your responsibility? Whose checklist is going to be on? And if we work together, then we can get started right away on getting a plan built. Now, what do you bring to a session like this? If you have financial statements, bank accounts, it's really helpful for us to have a full copy of one statement, a recent statement from every account. If you have investments, it's good to have an annual statement or quarterly statement. So if you just got one at the end of the year or one from last quarter, those are generally the best. The reason we like those is, remember that when we're planning, we are trying to preserve your assets. So it's important for us to know exactly what your assets are. So that's why we ask you to bring those. In addition, if you have an existing estate plan, bring it in. Bring it in, and if you actually get it to me ahead of time, we can review it with a little bit more depth, and I can address it during the actual meeting. All right. Now, in addition, one of the things, again, we like to make clear is we have a second set of services, and those are financial planning. If you would like a second opinion, if you would like us to take a review of what's going on, or you're diversified, or you'd like to be educated in this area, bring in the full statements and we can actually do a portfolio diagnosis for you. It'll be in a separate session and we can tell you what we think. And ultimately what we often end up doing is preparing a full, robust asset map so that our clients have everything laid out in one place, know their net worth, know what their annual incomes are. We can actually do projections and living expenses projections based on those. Those are additional services if you are interested. So that's it. So as I indicated before, this is a defining moment. How are you going to be remembered? Are you going to be remembered as one of these folks, as a guy that or a gal that put your head in the sand? I hope not. As Pablo Picasso once said, only put off till tomorrow what you're willing to die having left undone. So don't hold this off for another minute, especially if you've been procrastinating. We love procrastinators. We'll get you in, we'll get an appointment, we will schedule it. We can often get these plans done in a couple of weeks, and you can walk out of the door with peace of mind, knowing exactly what has gone on. So when I finish up, I'm going to go to questions and answers in just a minute. But when I close out this session, there's going to be a link for you to be able to book an appointment online. You'll actually see actual access to my calendar. Click your favorite time, schedule it. But if this is not your thing, if you're not a tech person, don't panic. All you got to do is reach out to us, call us at our number, or email Caesar Gill, our operations director, and he will make sure that you get in to see me. We would love to see you. So that'll be up in just a minute. And so at this point in time, I will turn to questions and answers.